February edition of the SPSP webinar series. My name is Ken Ross. I'm the webinar coordinator for SPSP and a board member, and I appreciate you participating and attending today. I want to thank Sedgwick Brand Protection, as always, for their support and sponsorship of this webinar series. This is a program that has always been of interest to me. About 40 years ago, I was an in-house lawyer in charge of product liability, and my company sold all the power tools to Sears. And we had all kinds of issues, as you can imagine. And at any given time, I was defending 200 lawsuits filed against Sears that were tendered to me under our indemnification agreement. So the manufacturer-retailer interactions have always been of interest, and they're even more important today as we continue to have lots of private labeling issues and litigation issues, of course, and CPSC issues. So I thought it would be good to put together a panel that we have here today that's terrific, that all has experience with these issues. And first, let me just introduce the speakers, and you should be able to see everybody on the screen. Barb White is Senior Director, Assistant General Counsel for Regulatory Issues at Target Corporation. Obviously, her perspective is from the retail side, but she's dealing with manufacturers all the time, of course. Jenifer Keenan, Jenifer Keenan Law. Mike Daglio is a partner at McGuire Woods. Both Jenifer and Mike represent both retailers and manufacturers, so they have both sides of the issue, which is particularly good. I guess I would say over my 40 years of dealing with this, I've probably represented only manufacturers and dealing with retailers and not with retailers directly. So I have a few views on this, which I might interject here and there, but we got three wonderful speakers who I think can deal with a lot of different issues. Now, we've identified a lot of issues to talk about, and I'm not sure we'll get to all of them, but we'll try to get everything discussed that we can. Please ask questions. They'll show up. I'll try to filter them out. I may respond during the program to some of them and hold the others till the end. And just remember, every retailer and manufacturer is different. So we're not going to come up with at least, well, I get Barb, you can come up with what you want to do, but that doesn't mean every retailer wants to do that. So every situation is going to be a little bit different. And probably the main message I would throw out here is if you're a manufacturer, you need to sit down with your retailer and find out what they want you to do, what they don't want you to do. How do you work together? How do you coordinate to make each other's jobs easy? And so that you don't have problems going forward with a lack of direction, a lack of timeliness, a lack of information. Our last one of our last webinars was on call centers, which is a good example of that manufacturer-retailer coordination. What kind of information should the call center for the retailer be getting, or what should they do when somebody calls and they have a safety issue? So there are a lot of issues to talk about, but it's so I guess we're going to be doing a lot of identifying of issues and some answers from each of our speakers' perspectives. But from your standpoint, you need to take that and figure out what that means for your company, whether you're a manufacturer or a retailer. Okay, with that, I want to turn it over to Barb White to get started.
Well, good morning and good afternoon, everyone. It's great to be here. Ken and Jenifer and Mike and I have worked together over time on a variety of issues. And as you can imagine, a retailer such as Target, where we carry such a wide variety of products, we encounter product safety issues in a wide variety of ways. And they range from, regulated product issues to hazards that may arise in the context of the guest using the product. And so from time to time, we've worked together on each of those issues. I'm going to start by talking about sort of some best practices when launching a recall, or really more when considering a recall, as you begin to think through that. And So I've been asked to provide sort of the what would the retailer like to see perspective. And so I will share that, of course, as a practitioner, not necessarily speaking directly on behalf of Target, but as from a general perspective. So starting with when you start to see issues as the manufacturer, Target is also monitoring a wide variety of guest feedback. I think that last count, we had 13 different channels for guests to provide us feedback, including we received one fax last year. We didn't even know we had a fax way to receive faxes, but apparently we do. And so with that in mind, we are gathering guest feedback, and we expect that you will also be gathering guest feedback, whether you're out looking at the product reviews on your retailer's sites, or whether you have your own 800 number on your packaging. We expect that manufacturers are listening and keeping their ears open for potential concerns. And when you find a potential concern, something that can cause some difficulty is making a change to the product without notifying the retailer. And in particular, making a change to the product and then continuing to use the same UPC or item number. There can be a lot of reasons why that might make sense from a business perspective. You don't necessarily know if this is going to be the fix. You haven't necessarily decided that this guest satisfaction issue is really a hazard. Maybe it's more of a quality issue or a product improvement. But understand that when you make changes, if you're not notifying the retailer, if you're not changing that packaging in a way that allows the opportunity to distinguish between the old product and the new product, if that thing that you've tried to correct later becomes an issue, you may be unable to distinguish the good product from the bad product. And so that's something to keep in mind. We also know that the CPSC has not looked kindly on kind of a series of engineering changes to try to address hazards without reporting. And so that's something to keep in mind as well. And I will say here, always a good idea to, when you've identified a potential safety issue, make sure you're talking with the quality and safety team at the retailer that you're dealing with, as opposed to probably your usual contact, who is the buyer. The buyers have lots of inputs. They're responsible for lots of products. Thankfully, the number of products with issues is always going to be substantially smaller than the number of products that we sell. But the quality and safety teams are in the best position to help you think through how that might impact your stock at the store, and make sure that if it is something that the retailer needs to be reporting, that that's happening. And we can also coordinate then in terms of, does there need to be a change in UPC or packaging that will allow us to distinguish that product further down the line. Another thing that we really like to know is if you are moving forward with a recall, we like to know that that's happening. We would like a best case scenario to remove that product from sale when you initiate that process. We don't want to continue to sell product that has a potential safety hazard. We assume you don't want to either. From a product's liability perspective, we can mitigate that risk by not continuing to sell the product. And so communication with the retailer and letting us know, hey, we're getting ready to possibly recall this product, and we'd like you to stop selling it. We will always welcome that communication. And there can be some confusion, and I know others are going to talk about this too. There can be some confusion about whether or not CPSC will let you talk to us. That is not, in our view, a legal barrier, and we are certainly in a position to keep that information confidential within Target and not to share information externally with respect to the fact that a product has been removed from sale. And so more communication earlier from our perspective is always better. I wanted to touch on also our reports to the CPSC. So Target is a member of the Retailer Reporting Program. There are only, I think at this point, 4 official members of that program that are retailers. The 5th one is Walmart, and they, I think, participate in a little bit different way. But as a part of that, we report weekly guest concerns that have come to our attention, and we categorize those guest concerns in a variety of ways, so that we're not reporting every guest concern that comes in, but we really are focusing on safety concerns and potential safety concerns. As a part of that, we provide what we call a vendor issue notification. That vendor issue notification goes to the manufacturer or vendor of the product. It will identify the verbatim of how the product issue was described, and then it will also identify things like our item number and things of that nature. Some of the questions that came in from Ken and others were, are we collecting those products? Many of the products that we get feedback on, we get as product reviews or as what they call concierge or chat. So it's not someone bringing that product into the store to return it. And so it is very rare that we actually collect the product that the person has complained about. Likewise, we have 1,800 stores. And so these kind of onesie-twosie complaints that come in when guests are returning a product, it may be very difficult to identify those samples. What I will say is that we do ask guests who are providing product reviews or who are calling our hotline in particular, whether or not we can share their contact information with the manufacturer. And for privacy reasons, of course, if they say that we cannot, then we will not. But if they say that we can, we absolutely will. And our experience has been that where the manufacturer reaches out, they are frequently much more successful at collecting that sample from the guests, and also at getting the guests to respond to them. We have a lot of situations where the guests describe, in some instances, rather alarming concerns. Whether they've characterized it correctly or not is sometimes a little bit uncertain. We have a kind of a running discussion about how many things actually explode. But nonetheless, they may say some fairly alarming things, some very concerning things. And then when we have our guest services folks reach back out to them to try to gather more information, they may not be responsive. And so our experience has been they are more responsive to the manufacturer or vendor than they are to Target. I wanted to touch on, so as Ken mentioned, we've got kind of a list here, and I'm just wanting to make sure that that I touch on a lot of these things. I mentioned that we really value communication in advance of a recall. I will also point out that it's really very beneficial for manufacturers and vendors to engage appropriate product safety counsel. So I'm an in-house lawyer. I don't bill my time. I don't get paid to recommend other lawyers or I don't have partners who I can send you to if you're a manufacturer. So this is a completely disinterested comment, right? This is really just only based on Target and what is helpful to us. And that is really, really please engage good product safety counsel. Not the guy who did your lease, not your brother-in-law who put it together your corporate documents. Get good product safety counsel. It's a fairly small bar. There are folks who really and those folks will be familiar with the regulations. They'll be familiar with how to file a report. They'll be able to provide you with some insights about whether or not this is something that's likely to end in a recall. And they will be talking with the agency. They'll be familiar with the staff often in ways that can be super helpful in working through your process. If you're going to do a fast track recall, they can make sure that that's happening as quickly as possible for something that you really want to just get out of guest hands because you've identified an issue and you want to move safety to the forefront and not only stop selling that but give people notice. Or if you've got a product that's maybe you've seen some concerns, you want it to go through the whole preliminary determination process, those counsel such as Jenifer or Mike and others and can really can really help make that process go more smoothly. And so I would just encourage that. As retailers, we really appreciate when we have when we can interact with other expert counsel. So kind of out of order here, but what are retailers willing to do to satisfy the CPSC product destruction requests? And I guess this is sort of a subtopic of just a general broader topic from the retailer perspective, which is, I'll touch also on the kind of the template, the corrective action template here. CPSC is increasingly requesting more and more post-recall activities with a great deal of specificity. They may be asking for photos of destruction. They may be asking to witness destruction. They may be asking for certain types of social media postings. Please remember that retailers have a standardized process for recalls, whether that's an owned brand recall or whether that's a national brand recall. And we will absolutely execute that process for each recall. We will make sure that the item is locked and that sale is prevented. We will remove that product from our shelves. We will have a process for when someone makes returns for destroying that product and making sure that it doesn't get put back on the sales floor. But that being said, it is not a negotiable process. It is not a process that can be changed for any individual recall. There are a lot of systems, computer systems involved that have been programmed over a number of years in order to accommodate this. And so as you're negotiating your corrective action with the agency, please remember that this is your recall. And so you can commit to do the things that you can do, but please do not attempt to commit a retailer to do, whoops, there goes my light, anything in particular, because we may not be able to do that, or we may not be willing, let's be frank, to do that. So we are happy always to tell you what our processes are, but a great example of this is Target, for example, does not post recall posters. We have iPads at the front of the store and in a variety of locations throughout the store where guests can identify recall information. We actually have the capability to print out those recalls at most locations so that you could ask for a printed copy of the recall to take home and compare the model numbers or the photos that are in the recall to the product that's in your house. But because of that, we don't post recall posters. Over many years, we found that those posters had a way of walking off. It was difficult to keep them fresh. It was difficult knowing the number of products that we sell, the fact that we also sell food, to have those recalls posted for a length of time. And so this way, everything is accessible. All the recalls since we instituted this process, which is now, I think over 10 years ago, are available on that iPad and also on our target.com website. And we think that that's the best way to convey that information to our guests. But we also will not, you can send us a poster, we're not going to hang it up. And so, and the CPSC knows that, but, depending on the individual compliance officer, they may not know that. And so just, that's a good example of something, that we would ask that you not commit retailers to do anything in particular, because that may not correspond with our process. And then there was a question, or we were also wanted to talk about social media and communicating with social media to customers. So as a retailer, we have a variety of ways that we communicate to guests if they have purchased a product that has been recalled. We are generally, so we are not, of course, able to communicate directly with someone who's come into our store and paid cash. We don't know who they are, and we don't know where they went. there are some retailers who have membership models. Costco is the, prime example. Costco knows everything that you bought because you bought it with your membership number. We don't have that advantage with respect to all consumers, but more and more we have some information, because if you use your Target Red Card, or if you order something as either pickup or drive up, because you've ordered that digitally, we now have a record that your username has purchased this product. And so we have email notification that will go out to all of the email addresses that we have on file for folks who have purchased a product digitally. And that now includes pickup and drive up because of the way that you make those purchases. Likewise, we have what we call Red Card Dialer, and an email for anyone who has a Target Red Card that includes not only our credit card, but also the debit card. And the most recent thing that we've been able to do is we've added what we call push notifications on our app. So if you have the Target app and you have, you permit notifications, which I'll be the first to say, the number of apps that want you to permit notifications can sometimes be, a little overwhelming. But I'll just put in the plug to activate notifications on your Target app, because we will send you a notification if you have purchased a recalled product. We have over time worked with different forms of social media. We currently have a product recalls page on our Facebook page, and that links directly to the CPSC press releases. We have used our Ask Target handle on Twitter, which is kind of our guest services handle, to publish recalls on Twitter. I will say that, that is not necessarily the breadth of audience that you would expect. And we've really kind of challenged the agency about that, in part because all of our sites are commercial sites. And so we know, like if I'm friends with Jenifer on Facebook, I will see most of Jenifer's posts because we are individuals who are friends. But even as someone who works for Target, I don't necessarily see all of Target's posts because they're commercial posts. So they would have to be boosted or otherwise brought forward. And so with that in mind, we're not convinced that social media is as effective as some of the other notifications. And so with that, I think I'm at my time, based on when we got started here, Ken. So should I pause for questions here?
No, let's do this. Since we started a couple of minutes late, we'll hold any comments from Mike and Jenifer on what you said till later, and let me turn it over to Jenifer, if that's all right with both of you.
Perfect. Yeah.
So Jenifer, I'll turn it over to you to add your comments. Thank you.
Well, good afternoon, everyone, or I guess good morning to the people who are probably west of the Mississippi. I'm going to talk about the importance of the coordination between the retailer and the manufacturer. As Ken said at the start of the seminar, I represent both manufacturers and retailers before the CPSC. And Barb talked about what she likes to see as the in-house counsel at a retailer. And what I'm going to focus on is how the manufacturers can help achieve some of those things that Barb says that retailers like to see. So from the outset, when I'm representing a manufacturer, one of the first things I tell them is that we want to make this process as easy as possible for their retailer. This is the manufacturer's recall, not the retailer's recall. And retailers understand that recalls happen. They happen all the time. If the manufacturer can make the process as easy as possible for their retail customer, it'll go a long way to preserving the relationship and allowing that manufacturer to continue to be a supplier to the retailer. So I am really wearing two hats when I represent the manufacturer. I'm working with the CPSC, negotiating the scope of a recall, negotiating the remedy, working as best I can to represent the interests of the manufacturer before the CPSC. But I'm also helping the manufacturer maintain their relationship with their retailer. So with that in mind, some of the key issues are: when should the manufacturer tell the retailer that a recall is coming? And as Barb said, as soon as possible. There used to be a conflict that the CPSC did not want, or a perception, I guess I should say, that the CPSC did not want manufacturers to utter any information about a possible recall until the CPSC had announced the recall. So it really put manufacturers in a difficult position. So I feel, as Barb alluded to, that the CPSC is backed down from that position, and sophisticated retailers know that information about an upcoming recall needs to be held confidential. It can't be publicly announced until the CPSC announces it. So I think that's the key. It's that the recall should not be publicly announced until the CPSC announces it. So a manufacturer again should tell their retail partner as soon as possible, hey, we have a potential product issue. We'd like you to institute a stop sale. We're negotiating with the CPSC on a possible recall. We'd like to institute a stop sale. Because the earlier that the retailer can institute the stop sale, the better it is for everyone. It's better for the retailer, it's better for the consumer, it's better for the manufacturer. And the CPSC certainly appreciates a stop sale early in the process, because that is one of the best ways to protect consumers and limit the number of potentially dangerous products that get into the hands of consumers. So again, it's critically important that manufacturers tell their retail partners as soon as possible that they are working on a recall or a potential recall. Another thing that Barb alluded to, it's very difficult if a manufacturer tries to agree to things on behalf of the retailer. For example, one issue is distribution of letters to consumers. This is handled different ways. The CPSC expects that all known consumers will be notified about a recall. Most of the time, the manufacturer doesn't have that contact information. The retailer does. Some retailers may tell you, we as the retailer want to notify our customers directly. In that case, you would provide a CPSC approved consumer letter, and the retailer may or may not use that, to Barb's point, depending on the format that the retailer likes to use to notify the customers. I would say, I don't know, 5-10 years ago, it seemed like sometimes the retailers would provide the customer contact information to the manufacturer and say, okay, here are the email addresses, here are the hard copy addresses. When we used to have to send out hard copy letters, you manufacturers send them. But I think that's probably, most retailers aren't doing that anymore. So with that in mind, if the CPSC tells you, hey, we want you to send 8 letters to consumers, well, if the retailer is going to be the one responsible for sending out those letters, you can't make that agreement on behalf of the retailer. All you could do as the manufacturer is say, well, I can ask the retailer to send it 8 times, but I don't know if they're going to do it. Again, to Barb's point, retailers have a very specific process with respect to recalls, and they're going to follow that process. So it's just something to keep in mind. Another thing that I think you really need to work closely with your retail partner on is the remedy. Sometimes products are returned to the store. Sometimes they're returned to the manufacturer. And you need to have an understanding of that early on. You know, if there's a national product that's sold among 20 different retailers, depending on the type of product, it could be that it's going to be more streamlined and more effective for consumers to send that product directly back to the manufacturer rather than rather than return it to the store. So again, you need to have a discussion with your retail partner early on about what process will be used for getting the recalled products back from consumers. Barb also touched on product destruction. That seems to always come up. I think long ago, it seemed like the CPSC was more willing to accept a certificate of destruction that would have a few pictures of the destroyed product, list the number of products that were destroyed, how they were destroyed, and that was sufficient proof. More and more, they're requesting to come see the destruction. So to Barb's point, if the product is returned to stores and the stores follow their normal process of destroying the product, they're not going to be able to provide you a certificate of destruction. If the products are sent back to the manufacturer and they're quarantined in a distribution center or a warehouse, then when it comes time to destroy the product, you have to reach out to the CPSC, say, okay, you know, we've gotten all this product back from our retailers, from consumers. Now we want to destroy it. Here's the plan. Here's the method we're going to use. Please let us know if you'd like to witness the destruction or like a certificate of destruction. And again, it seems more and more they're saying we'd like to come witness the destruction. So it's just something to keep in mind. Make sure you don't represent that the CPSC is going to be able to go to a Target store and witness the store's destruction of the product. Because again, the retailers have their process for destroying products, and they can't tailor that or customize it to your particular recall. So these are just a few of the things, again, to keep in mind, that you're not making promises on behalf of the retailer that they can't do or won't do. Now, kind of shifting gears a bit, although it again is related to having notice with your retail partners and keeping them in communication. And a big issue that comes up is when the retailer is named in the press release. Ideally, you've had constant communication with your retailer as you're going through the recall process. So the initial, communication with your retailer would be, we're going to do a fast track recall with the CPSC. Please stop selling the product. That would be a great first, communication. Then to touch base with them, we're working through the recall process. Looks like we're going to have a final press release in a week. The CPSC is going to name you, retailer, as one of the retailers in the press release. Then when you get a final draft of the press release, you can send it to the retailer. Hey, this is the draft that's been approved for clearance. As you can see, you're going to be named in the press release. Then when the CPSC tells you, okay, we're going to release the press release in 10 days, and they give you a date, as soon as you know the date that the press release is going to be released by the CPSC, tell your retailer, because they're going to have to have their customer service people ready. If the product's going to be returned to the store, they have to have all those processes in place. So again, the earlier you tell the retailers of each of these critical steps, the better it is for everyone. And importantly, for the manufacturer, the more chance you have of maintaining that relationship with your retailer.
Jenifer, can I just chime in here? Sometimes too, depending on, hopefully these are all recalls that are associated with, bumps and bruises and not serious injuries. But where you have the unfortunate situation that something has been associated with a serious injury, let's say a house fire, for example, we also have processes internally to let, for example, our communications folks know, to let our executives know, hey, Target is going to be named in this recall, and this could, this could be something that gets some media attention. And so we, not only do we want to have the product, off the shelves and locked down and all of those things, but we want to be prepared from a communications perspective in case we get inquiries either through guest services or through the media.
Oh, what, can I add one thing myself? If you tell them 10 days before or well before the, you might tell the retailer before you actually have a final agreement with the CPSC. And the CPSC likes to see your communications and approve them to the retailer. But at some point, I just do a stop sale letter and don't even bother getting it running it by the CPSC. And then the ultimate letter where we announce, send the press release out that's going to go, that's the one, the communication that's approved by the CPSC. So think about whether you want to actually go try to get CPSC approval on that initial communication to the retailer to stop sale.
Oh, and maybe I misspoke. I agree with you, Ken. No, I don't get approval. What I meant was the letter to consumers. So the letter that's going to go out to the consumers, the CPSC likes to, approve that letter. But no, your initial communication to the retailer, that, again, needs to be done as soon as possible. And I don't get CPSC approval for that from that. Okay. Gosh, this time has zoomed by. I have a lot more topics on my list. So let me just maybe go to a final topic here, and that's the difference between national brand and private label. As I alluded to, when it's a national brand, oftentimes that's sold among many different retailers. So that makes your job harder if you're the manufacturer of the national brand, but you need to make sure you're coordinating with all those retailers. All of the steps that I talked about, you need to do that with all of the retailers. And then you also need to understand, as Barb alluded to, each retailer is going to have their own different process. Target isn't the only one that doesn't have recall posters. A lot of retailers now have digital ways of communicating about recalls in their stores. So the CPSC may ask you, national brand, to develop a recall poster, but understand that it's not going to be posted at all of the retailers. With private label, that's a very different situation. With private label, the retailer is actually wearing two hats. They are the retailer, but they're also the manufacturer, and often they're the importer of record. So they're handling the recall as both the manufacturer and the retailer. In a lot of ways that streamlines the process quite a bit. But sometimes, even though the retailer / private labeler is handling the communications with the CPSC and reporting, they're still going to need a lot of information from the manufacturer. So if you are the manufacturer of a private label product, you want to be responsive, timely, provide the retailer, private labeler, the information that they're requesting, and take it as seriously as the retailer is in reporting it to the CPSC. So with that, I apologize. I didn't get to many topics, but I'll be ready to answer them, answer any questions you have at the end of the webinar after Mike gives his presentation. Thank you very much.
Okay,
and
thank
let
you,
me
Jen.
just, oh, sorry, can I just add one? I just want to add one thing on the private label aspect, because Target has a lot of private labels. But many of our private label products are exclusive to us, but not all. And so sometimes a private label product may be something that the manufacturer is seeing issues across the lines through which they sell that product. Maybe they are selling it under their house brand as well as selling it through a number of retailers, and they might be seeing an issue before, for example, Target is seeing an issue because we're not selling all of those units. So we may not see that it's, we may have 1 or 2 incidents, but maybe the manufacturer is aware of 10 or 12, for example. if we would always ask that if you're going to start to interact with the agency about a private label product, that you notify us and include us as a part of that process. Because that is, you know, that is product that we that people identify with us as distinct with national brand product that they identify with the brand owner. So that's a time to really hold hands. And again, we're not going to tell you like, don't report to the CPSC, but we want to know what's happening and we want to be aware of it, so that we can act accordingly and so that we aren't surprised on the back end.
Okay, thank you all. Just to remind everybody, our stop time is 2:15, so we're going to go 15 minutes extra. So Mike's going to go till around 2 o'clock, but we'll still have time for some Q&A or comments by all the speakers on what we've talked about. And I'll apologize. I'll add to Jenifer's apology. There's so many topics we came up with, and time always goes faster. I'll just say, as the website, the webinar coordinator for SBSB, we might have to do another one of these later in the year and just do the subjects we didn't get to. So it's all kinds of very interesting issues. Anyway, one other thing, somebody asked earlier that I was stuck on this one slide. Well, the reason is because we don't have any substantive slides, partly because we had so many small issues to talk about that really didn't lend itself to slides. So I have one more slide to show you everybody's email address to ask them questions if you want. So I'll do that, but that you're not missing any slides because I forgot to advance them. Now I'll turn it over to Mike Daglio.
Thanks. So like Jenifer, I represent manufacturers, importers, and several retailers, and have been doing that a long time. And very much agree with Barb and Jenifer's comments today. I think if all manufacturers were following those suggestions, there would be happier retailers in this process. So my comments aren't going to apply to all retailers, and they're not going to apply to all manufacturers. So hopefully you can take away from this a few things that you can apply, to your products. And the first issue I wanted to raise was, and this was alluded to or addressed by Barb a little bit, was product or manufacturing changes that are implemented that are done concerning a safety issue probably will require reporting, or at least consideration of reporting, to the CPSC. And companies are able to make quality improvements to their products or just changes to their products, and that happens all the time. But sometimes there is a change to a product because of a safety issue. And engineers are really good about identifying a problem and fixing a problem. But the CPSC is very good about looking at what engineers have done and said, well, the engineer identified the problem and fixed the problem, and therefore this was an issue that should have been brought to the CPSC's attention. And while parties may not agree on whether that's true or not, it's definitely an issue that you always want to be aware of as you are making changes to products. Now, that's not necessarily a retailer issue, but it can be, particularly if you communicate with your retailer about changes to your products. And there was discussion about private label. Well, if you're supplying a private label product, you probably are communicating more with that retailer about changes, engineering change notices, why changes are being made. And so you need to be aware that when there is contemplation of a change or a change that's being made because of a possible safety issue, that's something that you need to be thinking about, or I would suggest that you think about with your in-house or outside counsel, like Barb said, somebody who can bounce things off of, and they can give you that input. So that ties into my second comment, which is communications the manufacturer has with a retailer are generally not going to be, quote, protected. So you've all heard about the attorney-client privilege. And so things you share with your lawyer are generally protected from disclosure, but there's no manufacturer-retailer protection. So it's really the opposite. Anything that you say to your retailer and anything your retailer says to you, you should assume should it be relevant to either litigation or a CPSC investigation, may need to be produced. That's different when lawyers talk to each other. There's a whole nother set of considerations there. But I'm just talking about the routine back and forth that you're going to have between a manufacturer and a retailer. And so you want to be aware of what you're communicating and why you're communicating it. And so sometimes, you know, people, as they're in a hurry, they might indicate something that may not be a true reflection or a full reflection of what's being done. So we'll give you an example. Let's say that there is a product change, and the reason was many parts. It had to do with cost, it had to do with quality, it had to do with, you know, the customer experience, and maybe potentially there was a safety issue. But if you're not clear on all of the reasons why, and you've only addressed one of those issues, the retailer is going to be dealing with that, and you're going to be dealing with that. So just be aware as you create things in writing that it's a true and accurate reflection of what you want it to be. So my next two suggestions or comments have to do with if there is a problem. And I would suggest that if you're not already doing this, that you consider the benefits of things like date codes, serial numbers, and other ways of distinguishing products. And I know that's easier said than done. If it's a TV or something of that size, of course, there's going to be something like that. And if it's something smaller, you know, maybe not. If it's, let's say, a piece of furniture, that may not be something that you would normally think of going through that extra effort. But the cost associated with having some kind of indication of when that product was made can really pay off for both the retailer and for you. So let's say that you've identified a potential issue, or there'd been a report of a problem that comes in. And so obviously that first step is, well, what's going on here? Because let's say you've been making this product for 5 years and you really never had this report, but suddenly there have been 2 reports of fires. And you're able to get photos back, or you're able to get the product back. Having some way of determining when that product was made might be helpful to you to narrow the scope of what's going on. Maybe there was a change in a component supplier. Maybe you had a new person working on the assembly line. You know, maybe there had been a design change that was perceived to be not all that significant, but I can't tell you the number of unintended consequences I've seen over the years where folks thought or made some change and then there was some other outcome they weren't expecting. So having that ability to know, okay, this product was made in this time period, and I'm not suggesting that you need to have it down to the day, but even being able to narrow it down to a month or even a quarter could be really helpful as you try to then determine, okay, what's the problem? And then to take the next step, what do we need to do about that problem? So go ahead.
Can I jump in for a
Yeah,
second?
please.
On this point, because I have a classic story. I had a disposable cigarette lighter manufacturer that had all the codes on there, but they packaged it in a way that hid the code. So it's going up in the retail stores, and we want to get a month's production back with this code. You couldn't read the code, so we had to get everything back. Open up all the packages. So put the code on there, but package it in a way that somebody at the retail store can see the darn code. How's that?
So you went exactly where I was going next, Ken, which is it's great to have the information on the product itself, but now consider the fact that you're dealing with a retailer and you've identified an issue that needs, let's say, sorting. Let's just go ahead and say in this scenario that you want to do a recall, or you need to do a recall. And so you've identified the problem and the scope of the problem. And let's say it's just literally 6 months of production. Well, to Ken's point, if that information's buried in the packaging, it's not going to do you a lot of good when working with the retailer, because you all are probably not going to be opening up boxes in the middle of the aisle and behind. There's just not, in most retailer situations, not that luxury. But if you have information on the box too, and it doesn't necessarily have to be the serial number, but even if you have some kind of information on the box that lets you correspond to what's inside the box, like you're using different date codes by quarter or whatever. And so in a situation that you needed to do sorting, you could quickly look at the box and understand, okay, is this in our time period or not in our time period? So that dovetails with my next and getting close to final comment, and something that Barb mentioned as well, which is the SKU or the UPC code. So technically, if you're doing a recall, from a manufacturer's perspective, you need to address the problem, get it out of the marketplace. The retailer needs to be sure that they're not selling it. But the best way to do that is to lock down that SKU and essentially not use that SKU again for that product. Because what that does is it allows the retailer to turn it off at the register. And if you take that in conjunction with what we just talked about, and let's say you have half the product that is on the shelves of the retailer is not affected, and the CPSC is in agreement on that, in theory, you can go through, use a new SKU, label the box appropriately with the new UPC, and immediately have that SKU available for sale, so that there's no risk of the old SKU, what's being recalled, being sold, which you don't want, and the retailer does not want, and the consumer doesn't want it. But it also is allowing you, the manufacturer, and the retailer to sell what everybody agrees is perfectly fine to sell. And so that takes planning, going back to the last comment there, and that the better you position yourself to be able to make that change going forward. And look, some retailers, that's not going to work for them, but you won't know unless you're positioned that you can do it in a way or propose something that might make sense. And to Jenifer's point, you do want to make this as easy as possible. And the retailer wants to sell your product. I mean, the point is that it was on that shelf before this happened. And so as painless as you can make this, the happier everyone's going to be. One, really getting down to the weeds point here, if you're a real prepper, I would say you could even give some thought to not only the outside of the package, but the inside of the package. So a lot of retailers would say, okay, we're okay in theory, let's say, with you changing the SKU and the UPC on the outside of the box, but you also need to change the label on the product or on the instructions, let's say, because the instructions have the old SKU number on there. Well, having some thought on the front end when you're designing this product and the packaging of how you might access it in the event you ever needed to get into something is, I'm not saying manufacturers go through that thought process, but I'll just throw it out there now, since I have the benefit of talking to you, that if you are set up that when you open the one side and that's where the instruction manual is, that might put you in a better position, God forbid, you're dealing with this down the road. So my last comment is simply, if you're selling to a large retailer, the odds are either you're selling subject to a buying agreement of some kind, which is laying out all of your obligations to the retailer, or there's terms and conditions on their website or somewhere else that are being agreed to by you when you fulfill that purchase order. And if you don't know what your obligations are, whether it's a buying agreement or terms and conditions or anything else, it's probably in your interest to have a better handle on that, because you don't want to be figuring that out for the first time if you have a problem. And again, there may just simply be POs that you're fulfilling, and that's going to be less of an issue. But if you're dealing with a large retailer, you're dealing with a private label situation, you're going to have a lot of responsibilities to that retailer, more than just wanting to keep them happy. And to Barb's point early on, and this is not a plug for outside counsel, but If you find somebody that you're comfortable with and you can bounce ideas off of, you will generally be able to move faster and keep your retailer happier through this process. So I think I finished with 1 minute to go there.
I'm going to add a couple of things to what you said, Mike. One, to go to Barb's point, hire, well, if you have inside counsel, that's fine, or hire outside counsel who know what they're doing. But Mike, you can agree or disagree with this. I mean, there is a way to at least argue attorney-client privilege, I'll say, under the, if you establish what's called a common interest agreement between the retailer and the manufacturer's counsel. So it is possible to try to shield some communications between the manufacturer and retailer if you have counsel on both sides. Not a guarantee, but it is possible.
I agree with that. That's what I was alluding to when I said there's this, but the general everyday communications back definitely not going to be protected.
Yeah, but two other things. One, we don't have time to get into the indemnification agreement between the manufacturer and retailer. I had so much fun trying to negotiate those things with these huge retailers, and they want you to indemnify them for everything. And I had to push back on it's 40 years ago now. I assume Sears doesn't really care about me saying this, is they wanted me to indemnify them for everything. And I said, no, I'm not going to do that. If your salespeople sell my product unsafely, I'm not going to indemnify you for that. And we had power tools being sold in an unsafe condition out of the stores. Now, I'm not going to indemnify you for that. So, don't just agree to a blanket indemnification. Think about what the retailer can do or not do as they sell the product. And the one other thing that popped up is that the advertising, the retailer advertising for these power tools showed our products in an unsafe condition. The retailer didn't ask us for approval on their advertising. So they were showing our product in an unsafe condition, and that could contribute to a lawsuit. So you want to think about the indemnification. You also want to think about how the retailer is selling your product and whether it is consistent with the way that you're providing warnings and instructions and proper use of the product. In any event, let me ask Jenifer and Barb if you have more comments, and then we'll go to a few questions here. Anybody want to jump in? Okay. All right. So I'm going to go in order here. First question, how does Target communicate back to the manufacturer on consumer notification reporting with respect to online and or digital order requests, it looks like, regarding email notification of recall? Manufacturers are required to provide the data to CPSC monthly. Did you understand the question, Barb?
Yeah, so I think it's how can you get the information from us for your progress reports? Hopefully that I'm understanding that question correctly. We do have a product investigations and removals team, and so they are the team that will get all the notifications up and send out the notices to the individual guests. They are also the team that gathers information about, how many returns we have, and things of that nature. So if you're communicating with us, we will make sure we get you to the right person, and then they can provide you with the information for your progress reports.
Next question, I think also, Barbara, would be for you. How do you deal with data protection? I think you kind of talked about it. I mean, the data privacy laws are all over the place. So how do you?
Yeah. And it's been interesting. It's been a number of years now since we had the recall effectiveness discussion workshop at the CPSC, which there were a lot of retailers and manufacturers present at that, but it actually came up then. It continues to be a challenge. One way to address that is to make sure that your privacy policy correctly reflects the fact that you may contact guests when you're required to do so by the government, and also for non-marketing purposes. So in this case, notifying someone of a recall is not a marketing notification, it's a safety notification. But making sure that your privacy policy reflects that is important. That being said, as I mentioned, if a guest tells us that we cannot share their information with a vendor, we will not do so. And so we have kind of processes in place to try to collect guest preference in that regard.
Okay. Any other comments from Mike or Jenifer on that? On privacy? Okay. I'll interpret this question here. Hopefully I'll get it right. In Europe, the responsibility to provide a remedy is on the distributors, but the remedy should be given by the retailers because consumers' rights are against the retailers. That's in Europe. In the US, who has the responsibility to give the money back? And I guess that sort of deals with the issue of, are they contacting the retailer, or does the retailer send the customer to the manufacturer to offer the remedy? Does it go both ways in any of your experiences?
Usually seen it one or the other. You know, either the remedy under the recall is to return it to the retailer. The retailer will provide the refund, and then of course charge that back to the manufacturer, or the recall announcement will specifically say, you know, this product should be sent to the manufacturer at this address. Do not return this to the retailer. So a lot of CPSC press releases have that language, you know, this should not be returned to the retailer. I haven't seen really a hybrid.
Yeah, it's most difficult when the remedy is not just a refund, right? Because that's the easiest to administer. We understand why, you know, a substitute product, for example, or even a recall to repair makes sense in some circumstances, but those are harder to administer. And the reality is that if somebody brings back a product and just says, I bought this at Target, you should stand behind your product, you know, I want my money back. We're probably going to give them their money back and work it out on the back end. But we try to, you know, have processes to direct them to whatever the remedy is that the manufacturer is offering.
Okay, when recalling a private label product, is the recall rate higher than for other products?
No, I don't think we've had that experience. I think our experience of recall effectiveness, and that could be a whole nother webinar, but our experience of recall effectiveness has much more to do with the price point and or the perceived hazard than it does with the brand.
I would agree with that. Same experience.
Yeah.
Okay. All right. One more question here, and then I've got something I'll raise. When manufacturers agree with authorities that posters will be placed in the stores, so Barb, you don't have to answer this one because you're not doing that. Do the retailers actually put up the posters? How long are they displayed? Well, the poster has the date. The CPSC makes you put the date on the poster as to how long it should be displayed. Does it have any impact on the consumer regarding the recall? Which is, you know, I'm sure we all not sure about that one. Any views on these posters? Are they effective at all?
You know,
they're
it's funny.
always by the bathroom. And so if the consumer goes to the bathroom when they're in the store, they might see it. Other than that, nobody's ever going to see the poster. So I don't know why the CPSC ever thought the posters were effective.
I'd be interested in Jenifer's experience here. But for a while there, we were actually seeing less requests for posters. It seemed like the CPSC was going in the direction more social media. I didn't ever think that the posters were effective. But then more recently, we've seen that as part of recalls where we're getting a poster to display. And of course, the retailer will display a poster if they're given one. In our situation, my clients that are retailers.
So I agree with Mike. You know, a long time ago, you always had to submit a poster for recalls. And then it seems that there was a period of time where the CPSC wasn't even requesting them, that they had come out of favor. Now they are requesting them again. But all you can do as a manufacturer is request that your retailer display it. So you can send it to the retailer and say, here's the CPSC poster. But, you know, as Barb said, retailers have their own procedures, and a lot of retailers have understandings or agreements with the CPSC that they're using alternate means other than posters. So, you know, a manufacturer can't force a retailer to put up a poster. And it's just important, to reiterate, if the manufacturer is conducting the recall, all of the agreements are between the manufacturer and the CPSC. The manufacturer, again, can't bind the retailer to do anything. And I almost think of it, going back to my law school days, as it's almost privity of contract. The contract for the recall is between the recalling entity and the CPSC. If the recalling entity is the manufacturer, your agreement is between the manufacturer and the CPSC, and you can't bind a third party to any terms of your agreement. I don't know if the CPSC views it that way, but that's how I think about these issues.
One issue on posters, I've had a major retailer, not Target, major retailer who wanted to charge my client to put posters up in the stores. So it was, I forget what it was. I forget what the cost was. It was like, $2 per store or something like that, but they had a lot of stores, so that would have been a fair amount of money. The other thing that comes up is the membership stores, those who have memberships for their consumers. And I've had one of those stores want to charge my client to mail the letters to their consumers. And that, which is an interesting issue, because I think we haven't gotten into this, but I think the manufacturer would be happy to mail or email a letter or communication to a consumer if they had that information. But the retailers don't want to give it to them usually if they have it. And certainly if it's a membership store, then they want to charge you to send out the letter or the communication to their consumers. So you have to deal with that. And so as technology develops and expands and makes it easier to communicate with consumers, the posters are a little bit of an antique. But how you charge for things and how effective you are in getting these letters out is going to be very important for your recall effectiveness, and also certainly in a defense of a product liability case. In 1982, my company did a recall, and we sent out, if you can believe this, we mailed out 8 million letters to everyone in America who might actually have this product. But we sent the letter to the retailer and asked them to send it to their customers. We got the customer list from most everybody we could. Well, a lot of the retailers threw away our letters and didn't send them out to the consumers. We got sued, and we had to use that whole process to defend ourselves. So while we're not talking product liability today, that is something that you need to consider in both attorney-client privilege issues and your relationships with the CPSC, but also in how do you show that you are a diligent company that tried to do the best you could, whether you're a retailer or manufacturer. And as maybe you remember from prior webinars, I've been an expert witness in recall effectiveness cases, and they are really hard to defend, really hard to defend, because you can always do more. So how you manage the paperwork, how effective it is, how you can say that I really didn't need to do any more, can be very important in showing that you were a careful, diligent, ethical company that tried to do the best you could, but you didn't succeed with this one particular plaintiff.
And I think that's a great point, Ken, is, just a reminder that all of the folks on the phone, contrary to what you may hear sometimes from stakeholder groups or from the agency, we do all take this very seriously. We want our guests to have good experiences with the products. The manufacturers want the guests to have good experiences with the product. We want folks to be safe. And when there is an issue, our goal is to, effectively remove that product from the hands of consumers, so that they are not interacting with a product that may be unsafe any longer. So, we absolutely want to hold hands and work together with you, our manufacturer partners, to effectively protect the guest, and that's always our end goal.
Okay, this slide here shows email addresses. If you're careful about how you ask questions, we don't want thousands of questions, but we're happy to respond to your emails if you have questions. the slides, which I know are minimal, but there'll be a link to the video of the webinar posted on our website. And there may be additional material that we'll put in there, articles or other things that relate to the subject. One last thing, we have a webinar in March where we'll be talking to actually a China expert to talk about dealing with foreign manufacturers and all the difficult issues that arise. And we can throw in some CPSC issues on that one too. So we'll talk about foreign manufacturers, whether it's buying a product or buying a component part from a foreign country. What are the issues you need to be aware of? ICFSO is coming up in a couple of weeks. SPSB will have a booth and a reception. We hope you stop by and see what we're doing and trying to do. And the last thing I'll mention is that SPSB will present our Fundamentals of Product Safety program in September. I announced in our newsletter it was June, but we moved it to September to give us a little bit more time. And it'll take place at Fisher-Price's headquarters in Buffalo. And it'll be a 2-day program. And it's really meant for those really starting off in product safety or who want to start off in product safety, not for people who've got 5 years or more experience with it. So we'll try to give them a good grounding in product safety as they move forward in their careers. Thank you to the speakers. Appreciate your insights. Thank you all for attending today, and we wish you the best. Thank you.
You.
Bye-bye.
Bye.